Our next article is about this for the New York Times. This is about a person who brought a complaint to their city about business they were doing with a company, and the company sued them and won a $4 million judgment. And so obviously the issue is freedom of speech, and the issue is retaliation for exerting freedom of speech. So we're going to read the Court of Appeals decision and see what they have to say and see what the law is. Maggy Hurchalla appeals the final judgment entered after a jury found in favor of Lake Point Phase No. 1, LLC, and Lake Point Phase No. 2, LLC, on a claim of tortious interference. Prior to trial, the South Florida Water Management District and Martin County were co-defendants, but the claims against them were settled. Hurchalla argues the trial court erred by improperly instructing the jury on her defense of First Amendment privilege to petition the government, entering the judgment against her when the evidence was insufficient to defeat her First Amendment privilege, and properly instructing the jury on her defense of common law privilege to make statements to a governmental entity for mutual and public interest, entering the judgment against her when evidence was insufficient to defeat common law privilege, denying the motion for judgment notwithstanding the verdict, giving an adverse inference jury instruction, and ordering attorney's fees as a sanction. We affirm on issues relating to the First Amendment and common law privileges and explain our analysis, and we affirm as to other issues without discussion. Okay. As to the jury instructions regarding the privilege defense, we determine there is no reversible error. As to the evidentiary arguments, we could determine the jury was presented with sufficient facts to conclude that the privileges were negated by malice on the part of Hurchalla. Okay, let's read on. This appeal involves a 2,266-acre tract of land in Martin County. The previous owners of the property planned to develop a subdivision of 20-acre ranchettes for which the county issued a development order for a large segment of the property. The development order allowed owners to mine limestone from the property. When the real estate market started to decline in 2008, the previous owners looked to sell the property. They contacted the district about buying the property. The property was of value to the district because of its unique location at the intersection of 3 different water basins and its potential for storing, cleansing, and then converting water to different areas, or conveying water to different areas. However, the district was not able to acquire the funding for the purchase. Since Lake Point had been a contractor building on the property for previous owners, it realized that there was a very economical limestone on the property that the company could use for its heavyweight construction business, so it purchased the property. Lake Point approached the district with concept for a public-private partnership to construct a stormwater treatment plant on the property. After the district oversaw an in-depth due diligence investigation, Lake Point and the district entered into an agreement titled Acquisition and Development Agreement for a Public Works Project. The ADA addressed the project in 2 phases, Phase 1 and Phase 2, based on the fact that a portion of the property was under a development order. As to the Phase 1 parcel, mining would continue under the development order. As to the Phase 2 parcel, which was not under the development order, it was contemplated that Lake Point would conduct mining to create stormwater treatment facilities, but as to that parcel, mining partners would have to be obtained from both the Florida Department of Environmental Protection and the Army Corps of Engineers. The project envisioned that evacuation of the limestone would create stormwater management lakes that could be used by the district for water storage and conveyance purposes. The agreement required Lake Point to donate the property to the district in phases over a 20-year period as Lake Point mined the limestone from the property. Because the development order was an encumbrance on the property, the ADA provided Lake Point would have a development order vacated as to portions of the Phase 1 parcel donated to the district. Since the county was a necessary player in accomplishing the project, the district and the county entered into an interlocal agreement for the project. The interlocal agreement expressly acknowledged the project's numerous water-related benefits. Mirroring the ADA, the interlocal agreement required the development order to be vacated as a portion of the Phase 1 parcel donated to the district. The county expressly agreed that it would take no action to otherwise create any encumbrances. The agreement also provided that until portions of the property were donated to the district, the development order would remain in full force and effect. The interlocal agreement allowed Lake Point to mine limestone on the Phase 2 property of the property if it obtained permits from the FDEP and the Corps. Once Lake Point obtained the permits, additional permission from the county to mine the parcel was not required because the project qualified as an exempt public stormwater project. The interlocal agreement also provided that Lake Point would pay the county an annual monetary contribution based on the amount of limestone mined. Over the next several years, Lake Point worked to implement the project. Lake Point commissioned additional engineering reports to ensure the project's success. It applied for and obtained necessary mining permits. During this time, the county monitored the project and never identified any problems. Hurchalla served as a commissioner from 1974 to 1994. She received numerous awards for her long commitment to environmental issues and served on state and regulatory environmental boards. When the county entered into the project in 2009, Hurchalla knew of the project and expressed a few concerns, but took no action in protest. In September 2012, local media published an article about a plan by Lake Point to convert the project into one that would supply water to the city of West Palm Beach for consumption use. The article alarmed Hurchalla. Prompted by the news article, by late 2012, Hurchalla became vehemently opposed to the project. This was the same time frame as the 2012 general election, which saw a change in the composition of the board of the Martin County Commission with the election of Hurchalla's good friend, Ann Scott, joining another close friend, Sarah Hurd, on the board. Hurchalla began expressing her disagreements with the project in a series of emails sent to close friends on the BOCC using their private email accounts. Messages were also sent to BOCC email addresses of Commissioner Ed Fielding. These emails encouraged the commissioners to copy and paste the statements and forward them in emails to other county commissioners and county staff. Hurchalla also began giving explicit instructions in her emails to her commissioner friends as to how to stop the project with various maneuvers. As found by the jury, the emails resulted in the county changing course and moving to thwart or at least significantly delay the project. In 2013, Lake Point sued the district and county, asserting claims for declaratory relief, breach of contract, and tortious interference. In an amended complaint, Lake Point also asserted 2 counts against Hurchalla individually, one for tortious interference seeking injunctive relief, and the other for tortious interference seeking damages. Regarding Hurchalla, Lake Point alleged that the new members elected to the board on the BOCC and leading up to and in conjunction with this change in the composition, Hurchalla started to engage in surreptitious activities targeted to interfere with Lake Point's interests. Lake Point alleged that Hurchalla scheduled and attended meetings and also had email communications with various members of the board, having a plan to interfere with the interlocutory agreement and the ADA. It was also alleged by Hurchalla began making numerous false and misleading statements verbally and writing to the board, the district, and others outside of normal public meetings. Lake Point specifically listed in the amended complaint 7 statements Hurchalla made in January 4, 2013, to an email sent to all 5 commissioners. Finally, Lake Point alleged that as a result of and in direct response to the efforts and false statements, the county began breaching the obligations. Okay. The district and county settled with Lake Point, which resulted in amendments to the agreements that were more favorable, and the county paid Lake Point $12 million. Lake Point abandoned its count against Hurchalla for an injunction. The only remaining count at the time of trial was for Hurchalla for damages, focusing on her alleged tortious interference. The jury returned a verdict for Lake Point, awarding $4.4 million in damages. The trial court denied the motion for judgment notwithstanding the verdict and gave notice of appeal. Okay, so that's pretty intense. There are important differences between the federal Constitution's First Amendment privilege to petition government and the Florida common law privilege to speak against and to another about matters of public interest. Our Supreme Court has explained the differences. Both privileges are qualified, meaning they're not absolute. Regarding the right of, both privileges can be overcome by a showing of malice. However, the types of malice necessary to overcome the privileges are different. To overcome the first privilege, actual malice must be shown. In contrast, express malice must be shown to overcome the Florida common law privilege. The Supreme Court described the difference in standards. Actual malice constitutes knowledge or falsity of reckless disregard of the truth or falsity and must be shown by clear and convincing evidence. Express malice under common law, necessary to overcome common law privilege, is present when the primary motive for the statement is shown to be an intent to injure the plaintiff. The plaintiff need only show this fact by preponderance, the ordinary standard of proof in civil cases. Okay. All right. The differences between the 2 privileges are important for understanding the proper interplay between the First Amendment privilege and the common law privilege. For example, the 2 privileges require different kinds of malice, actual malice or express malice. Hurchalla argued only express malice for her defense in the trial court. While she affirmatively requested an instruction discussing express malice below, she argued the trial court failed to instruct on actual malice. Additionally, regarding the interplay of the privilege with the elements and the burden of proof, defense counsel briefly argued at one time it was Lakepoint's burden to negate the privilege statements. However, the argument was virtually abandoned or countermanded by defense counsel repeated assertion that the privilege was an affirmative defense. Hurchalla made the following statement. At that point, in 2018, the district staff continued to suggest some vague storage value, but changed the emphasis to the stormwater treatment area that would be built on the site as a completion of the project in 20 years. A study was to follow the documented bends, and that study has not been provided. Several steps later, Hurchalla wrote in a bullet point, neither storage nor the treatment benefits have been documented. These statements are examples of competent, substantial evidence that clearly and convincingly proved that Hurchalla demonstrated actual malice in interfering with the contracts with the county and the district by making statements she knew to be false or with reckless disregard as to whether they were false. I don't know about that, guys. They represent statements of fact as opposed to statements of pure opinion. If the statements are a mixed opinion, statements would not be privileged. So far, I'm disagreeing with the Florida court here. I don't think this is right. It's also significant the false statements were emailed to two recently elected commissioners who each admitted trial they had not read the permits or studies conducted. Thus, upon our independent review of the record, we determined there was sufficiently clear and convincing evidence to refute the privilege. I'm not feeling it. Express malice, malevolent intent to harm. We also conclude there was sufficient evidence presented to the jury to prove that Hurchalla demonstrated actual malice towards the Lake Point through malevolent intent to harm. In addition to her January 4th, 2013 email, there are emails she sent to her commissioner friends instructing them in detail on what to do at board meetings to work towards violating the agreement, signed to her as Deep Rockpit, as well as references to herself as Miss Machiavelli. The evidence, coupled with evidence of her significant influence with the majority of the commissioners and her ability over time to have them assert oppositional positions they knew little or nothing about, was sufficient to enforce an inference of a malevolent intent. I'm not feeling it. Conclusion, having determined that Hurchalla has not demonstrated trial court error regarding jury instructions on defense and privilege, and the evidence was sufficient to allow jury to find in favor of Lake Point its claim as tortious interference, we affirm the trial court ruling and the judgment affirmed. And two other justices confirm. So this is a 3-0 decision by an appeal court in Florida. I don't think I can agree with this decision. There's obviously a very strong interest in communicating to the government and lobbying the government and a right to petition the government. So if these kinds of communications were being made to some other third-party business, who, if this wasn't being done to the state, if it was another business that had a contract and she was doing this kind of things, maybe, because then I would agree, tortious interference tends to imply. Tortious interference, as the name suggests, is when you tortiously interfere with a contract. So like putting poison in someone's ear could be tortious interference. So if this was business A doing business with business B, and I go say mean things about business B to business A, and business A breaks the contract, that seems like tortious interference. So if this were a private business, I'd be more inclined to agree, but it's not. She was communicating with her government. Now, there had been an election, and two of these government officials happened to be really good friends with her. My response to that is like, well, so what? There was an election. People favorable to her got elected. They were favorable to her, and they were communicating with her. My response to that is, so what? She had their ears. My response to that is, so what? She was telling them what she thought. She was saying what these things were. She was saying what she thought, and they acted on them. My response to that is, so what? They communicated outside of the normal channels of City Hall. She didn't go toward the public session. She communicated on emails. My response to that is, so what? I can't communicate to my officials in emails anymore? Is that what you're telling me? Every time I send an email to someone who's a government official, that's not proper because I did it behind closed doors? Not that a business has ever done anything outside of a public session, right? So I don't think I can agree with this decision. I have no major problems with the way they defined this common law privilege in Florida. That's fine. But to hold that as the right standard when we're talking about a government entity, I can't get there. I think there's a privileged interest in talking to the government, and they were really good friends of yours. And so you're like, yeah, this is what I think. They don't have this study. They don't have this study. Here's how you can go about killing the deal. Here's some recommendations on things you can do. My response to that is, so what? That seems like, and even if she had malice in her heart, even if she hated your guts, my response to that is, so what? That seems like a perfectly valid thing for a person to do. She hates you, and she wants to cancel the deal, and she wants her government to back out. Now, maybe the government isn't would be in breach of the contract. So as to the damages to the government, I don't have a particular problem with that. There's a breach of contract issue there, right? They had an agreement with the committee. The prior version of the board authorized these deals, signed a contract. The contract's binding. So if the government now comes forward and says, "Well, we don't want to do this anymore," breach of contract, no problem. So there are damages by the government for this action, and that could be something the government could contemplate as it's deciding whether to do this. Do we want to pay these damages or not, or do we want to allow this deal to finish? But like, to say that I can't lobby the government to say like this business is mean, go kick their ass. I can't get behind this. So I don't see this, and I cannot agree with this decision. Um, yeah, yeah. Banning the contract didn't have cancellation terms within it. I'm not even saying whether or not they were in breach of contract. I'm just saying it's a separate issue. I'm saying it's a separate issue from her lobbying efforts. So, whether or not it's a breach of contract is a wholly separate problem for the government. If they had a contract and they didn't have escape clauses, then they're liable for the breach of contract. But, the idea that you can breach a contract and get economic damages is established for normal civilians. If I have a deal with you, a normal contract with you, as long as I'm willing to pay for it, I have a right to breach that contract. You come with me and say, I want damages. I'm like, here you go. Here's your damages. I don't want to do this anymore. So you can economically breach your contract, and it's done quite frequently, actually, when it becomes economically efficient to do so in certain circumstances. And attorneys will sometimes advise people to do it for exactly that reason. But as to whether or not she had the right to petition, as to whether or not she had the right to send these emails, as to whether or not she had the right to even spread lies to her government, I'm like, well, that's a government. That's a First Amendment interest. So I cannot agree with this decision from the Court of Appeals. I very much hope the Florida Supreme Court and/or the U.S. Supreme Court takes it, because I'm not seeing it, guys. I am not feeling that this is a correct decision. This seems wrong to me on law. I think this is an incorrect statement of the law. So I can't get there. I thought, I honestly read these things because I saw the article and it seemed absurd. And I'm like, I read it to see what I think. And I read the decision. I'm like, not given the First Amendment principles I believe in, this seems like a wrong statement of the law to me. So this might be a 3-0 decision from a court of appeals, but I'm not feeling it, guys. I really hope the Florida Supreme Court takes another look at this and says, yeah, my analysis is, yeah, but it's the government. The government's different. That's kind of my analysis at the end of the day. And so I just can't get there. But that's the case. Good luck, Maggie. I wish you the best.